it's important to emphasize that where he or she has been declared bankrupt by a competent court. It's important because you see, you want to make an assumption that the council, virtue offici, can declare a person bankrupt, which is not right.
I agree with my learned friend entirely that I do not have the power to declare you a bankrupt. It's only the court, but for avoidance of doubt,
competent court.
we shall say a person who has been declared bankrupt by a competent court.
Yes.
Thank you, Madam Chair. I wanted to bring, I wanted also to, on the same issue, on how to remove the Secretary General. Madam Chair, I believe a criminal offense is a criminal offense. The penalty issue should not be, should be removed. We leave it if he or she is convicted of a criminal offense, regardless of the penalty that has been charged to him. So I was suggesting that we leave it for as long as he has been convicted of any criminal offense. He should not be the Secretary General.
The problem with that is that a traffic offense is criminal, and you may be convicted and fined 20,000 shillings, and then you're fired from the job. So we are saying that the nature of offense where it exceeds 6 months without an option of a fine, now we have moved to a stage where it's called a serious crime.
Chair, thank you. Through experience, one of the common forms of misdemeanors is abuse of office. When I look at the grounds for removal of a General Secretary, I don't know whether it was deliberate or inadvertent, but it would be important, Learned Attorney General, that the issue of abuse of office as a ground for removal be considered, because you are going to find it standard in all our pieces of legislation.
And no objection to having that included.
Thank you. I put a question that clause 27 be amended as proposed by Honorable Jonathan Odur, Honorable Basa Leroy, and the Attorney General. Those in favor say on the contrary, nay. Let's have it.
Clause 27 as amended.
I put a question that clause 27 as amended stands part of the bill. Those in favor say on the contrary, nay. Let's have it.
New clause.
New clause.
Madam Chair, insert a new clause immediately after clause. I beg for correction there, Madam Chair. It should be clause 27, not 26. Insert a new clause immediately after clause 27 to read as follows. Functions of General Secretary. Subject to the general supervision and control of the Council, the General Secretary shall A. be the Chief Executive of the Council, B. the day-to-day operations and administration of the Council, C. implement the policies and programs agreed objectives, performance targets and service standards agreed upon by the board. D. Manage the funds and property of the council. E. Advise the board on matters relating to sports and other functions of the council. F. Administer, organize, supervise, and exercise disciplinary control over the staff of the council. G. Keep records of the transactions of the council. H. Keep the minutes of the meetings and other records of the board. I. Liaise with the relevant National Sports Federation with a view of implementing the functions of the council and promoting sports in Uganda. A. And J. Perform any other function necessary for the proper implementation of this act or as may be assigned by the board. 2. The General Secretary shall, in the performance of his functions, be answerable to the board. Justification: to enhance clarity by stipulating the functions of the General Secretary. Madam Chair.
AG, just a slight modification. Why wouldn't we manage the assets and liabilities of the council as opposed to the funds and property?
It's more inclusive. So I propose that the amendment be made to that. We have no objection to the proposed amendment with that amendment.
Okay.
Right, Honourable Chair, I agree with the proposed amendment you brought. I have no objection.
Yes.
No objection.
I put a question that a new clause be inserted with the proposed amendment by the Attorney General. Those in favor say under contrary nay. The ayes have it.
Clause 28.
I put a question that clause 28 stands part of the bill. Those in favor say under contrary nay. The ayes have it.
Clause 29.
Clause 29. Chair.
Madam Chair, clause 29, Board of National Council of Sports. Clause 29 is amended by substituting for clause 2 the following. The board shall consist of the following members: a representative of the ministry responsible for sports, a representative of the Uganda Olympics Committee, 3 representatives of the national sports federations, one of whom shall be a person with disability. D, a representative of the education institutions elected by the education institutions. E, a representative of the private sector nominated by the private sector foundation who does not belong to a national sports federation. F, the general secretary who shall be an ex-officio member with no rights to vote, and the secretary to the board. Justification: to ensure that the board constitutes of members who are relevant to the promotion, coordination, and management of sports. Madam Chair.
Thank you. Harmonized position.
Madam Chair, the board shall consist of the following members: a representative of the Minister responsible for sports, a representative of 4 regions of Uganda, the northern, eastern, western, and central, one of whom shall be a person with disability, a representative of the National Sports Federation or National Sports Associations, a representative of the athletes, a representative of the private sector, and a person with experience in sports administration.
AG, are you in conformity with that amendment?
Yeah, we have a clause in here which says that the board shall consist of 7 members. There is a provision which says that the board shall consist of 7 members.
Now,
but this amendment has 9. So
minimum of 7.
Minimum of 7.
Minimum of 7. Now they are breaking that 7. Who comes from where? National character.
Madam
First,
Chair.
just hold on. Dr. Baiga.
Thank you very much, Madam Chair. I think we needed to also to be inclusive enough, because I didn't see a consideration of gender, although special interest group such as people with disability is considered. But I also propose to have a representative from the Uganda Medical Association. You need a doctor in this. Yeah.
Honorable Mpima.
Thank you. Thank you, Madam Chair.
Maybe what doctor is saying, the issues of gender are provided for under 4. on gender balance.
Thank you, Madam Chair. Madam Chair, whereas I appreciate the committee for considering a representative of person with disability, but I want to propose that this representative shall be nominated by Paralympics, since it is the national body that is in charge of sports for persons with disability.
That will come under SIA. Because now we are also going to say those people from different regions shall be appointed by us people from that region or cultural leaders of that area. So let's just leave that. It will be sorted out. It will be sorted out.
Right, Honorable Chairperson, I just want to make a proposal to amend on B, which we have harmonized 2 representatives representing the regions, one of whom shall be.
And certainly it would have made his famous father proud.
And the 18-year-old Gambian, left foot on the left foot. Oh my God!
And we know that we have primary, secondary, and tertiary. Their requirements are actually very different, and universities under tertiary. But under 4, this wording taking into consideration the interests of gender is not clear enough. In some interpretations by court, somebody can reason that yes, I took into consideration and then I came to this conclusion. I think the Attorney General knows the contention about issues of remand period, how it has been interpreted. So I would prefer that we just state here to comply with the Constitution that 1/3 of the 7 shall be women.
Right Honorable Chair, even if I wanted to disagree with a brother, with the honorable member, it is a constitutional requirement. So we can put it here and say 1/3 of whom shall be women. That's what the law requires.
It is at least 1/3. I put a question that clause 29 be amended as proposed by Honorable Duru, Honorable by Honorable Dur and the Attorney General. Those in favor say and to the contrary nay. The ayes have it.
Clause 29 as amended.
I put a question that clause 29 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 30.
Clause 30.
Clause 30, Madam Chair, the tenure of office of member of board.
The shadow attorney, the shadow sports minister, we are going to stop you from being shadow because you are not supporting our bill. He's the one who's saying no. The public should know that you're not supporting.
Clause 30 is amended by inserting immediately after subclause 3 the following. The minister shall, in prescribing the procedure for filling the vacancy under section 3, ensure that a person appointed to fill the existing vacancy serves for a term of 4 years and is eligible for reappointment in accordance with section 29(5). Justification to ensure continuity of membership of the board. Madam Chair.
AJ.
I'm proposing a redraft without taking away the principle. It reads currently that the minister shall, in prescribing the procedure for filing the vacancy, in subsection, ensure that a person appointed to fill the vacancy for a term is eligible for reappointment in accordance. I think here what we are trying to say is that we want to have continuity, but a person cannot be forced to stay if they want to go. Yeah, so I wanted to say that and shall not ensure and that a person appointed, and that a person, remove the word ensure, the minister shall, in prescribing the procedure for filling the vacancy under subsection 3, under subsection 3, provide that a person appointed to fill, provide, when you're putting out the advert, you say you are entitled to a reappointment, not ensure. Because if a person refuses to be reappointed, it will be a breach of the law.
Okay. Minister.
I agree with the new proposal which the Attorney General has brought forward.
Member?
No objection.
On this clause, I want to seek the indulgence of the learned Attorney General on the issue of timelines within which to constitute the board and within which to fill vacancies. Chair, I say so because we have many laws that have non-functional boards because of failure by the line ministers to constitute them. In fact, one of the reasons why I'm moving to amend inachievable law to have it repealed is because for 6 years there is no board, and yet things are happening there. And because the law is silent on when a minister should constitute a board, things move like that. So can we arrest that now that we are beginning to address issues of tenure and say, and this is for you, and ensure that once a board has a vacancy, either of one member or all the members, then the line minister must ensure that within maybe 30 days after the vacancy, it is filled to avoid a lacuna that is happening in most boards. Right, Honourable Chair, we even have a challenge. For example, the president has not appointed the governor Bank of Uganda because the law is silent on it. So you see the challenge we are having by failing to specify timelines. I want the learned Attorney General to have it considered under tenure.
Is there a vacuum in Bank of Uganda? What does the Act say, Bank of Uganda Act? It's not just a matter of saying yes.
No.
The Bank of Uganda Act is very clear. In the absence of the governor,
I think what Honorable Basalirwa is saying is actually a legitimate concern. However, I'm very careful always in putting straitjackets in legislation, because we may put a time, and if we don't meet that time, then what? Do we appoint a new minister? Do we cancel the board? Because we need to know the consequence of not appointing the board in the 30 days. If the board is not appointed in 30 days, does the board stand removed? Does the minister stand removed? So what I'm saying here is that what we can take away from here, right, Honorable Chair, is probably the minister is here. I'm informed. Is to take what we can take away from here is to say that as government, we have noted the concern you have raised in as far as executing the function, the executive functions as provided for in the laws are concerned. I don't know what you would propose would be a good time on that. I'll leave you to hear from, but it's a good concern. I only fear about straitjacket legal provisions.
This one?
Chair, when we passed clause 23, it read that the National Council of Sports in existence at the commencement of this act shall continue in existence subject to this act. I think the purpose was to ensure that when we pass this law, the current board is not disorganized.
No.
So that we can only add the other members to this. And then when the chairman had proposed commencement, he reserved certain clauses that would come into effect by statutory instrument prescribed, and I think one of those clauses, if I remember, relates to the operation of National Council.
But what Honorable Basalora is saying, that in the absence or in expiry of the council, how much time should be given for us to what? To fill. He wants the time element to be embedded in the law.
Chair, why? Well, legislations by nature are not self-executing. And if we have challenges in implementing them, then we should not make them. What is really the purpose of saying we have a board, the National Council of Sports Board, in the law, which we are not constituting? What would be the purpose? So I want to propose, Right Honourable Speaker, that under tenure of office, that whenever there is a vacancy in the board, the vacancy should be filled within 90 days from the date the vacancy has occurred. I beg to submit.
That is under 3. A vacancy on the board shall be filled using the procedure prescribed by the regulations made under this act within 90 days. Is that okay, AJ?
Madam Chair, that's
Minister?
okay. That's okay.
I
Proceed.
I put a question that clause 30 be amended as proposed by the Attorney General and Honorable Basalirwa. Those in favor say and the contrary nay. Then ayes have it.
Clause 30 as amended.
I put a question that clause 30 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 31.
Termination of appointment of the board.
Madam Chair, clause 31, termination of the appointment board. Clause 31 is amended in subclause 2H by inserting immediately after the word notice the words or sufficient cause, and B by inserting immediately after subclause 2 the following: the minister shall, before terminating a member of the board under subsection 2 A, B, C, D, E, or H, afford the member an opportunity to be heard. Justification: to take care of circumstances where a member might not be in position to give notice of absence as a result of factors beyond his or her control, including sickness, among others. Bullet 2, to provide for fair hearing before a member of the board is terminated. Madam Chair.
AJ.
The reading of 2H will give us a bit of a challenge if we take that proposal. It says the minister may terminate the appointment of a member of the board where for absence without prior notice or sufficient cause to the chairperson of the board for more than 4 consecutive meetings. I think it should be without prior notice for sufficient cause. Without prior notice to the chairperson of the board is absent for 4 consecutive meetings of the board without sufficient cause. I think that's what you're trying to introduce, that there must be sufficient cause for it. So it should be redrafted to read, for absence without prior notice to the chairperson of the board for more than 4 consecutive meetings of the board without sufficient cause.
Minister?
Pardon? Yeah, just what the clause is saying is just being absent for 4 consecutive meetings without sufficient cause is good to terminate your contract. So if, for example, you are unwell and you're in a hospital and you could not communicate, that is sufficient cause.
Honorable Minister.
I agree with the amendment proposed by Attorney General.
Member?
No objection.
I put a question that clause 31 be amended as proposed. Those in favor say on the contrary nay. The ayes have it.
Clause 31 as amended.
I put a question.
Chair, I just want to bring to the attention of the House the consequential amendment. When we are dealing with the removal of General Secretary, we did capture abuse of office. We also provided for declaration of bankruptcy by a competent court under clause 27, 5, subclause 5. And consequential, right to speak, Chairperson.
What is your amendment?
I want to move that abuse of office be included, and G, where a member is declared bankrupt by a competent court. I beg to submit.
It is
No
basically
object-
an inclusion
yes,
of
no
the G.
objection.
I put a question that clause 31 be amended as proposed by Honorable Attorney General and Honorable Basalira. Those in favor say on the contrary nay. The ayes have it.
Clause 31 as amended.
I put a question that clause 31 as amended stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
New clause.
New clause.
Madam Chair, insert a new clause immediately after clause, this should be clause 31, to read as follows. Directions by the Minister. The Minister may in writing give direction to the Council with respect to the policy to be observed and implemented by the Council. Justification: to ensure that the National Council of Sports adheres to policy directions given by the responsible Minister to facilitate a harmonized implementation of government policies and programs. Madam Chair.
AJ?
No objection.
I put a question that a new clause be inserted as proposed. Those in favor say on the contrary nay. The ayes have it.
Clause 32.
32. There is an insertion of new parts.
Yes. Madam Chair, before clause 32 and honorable members, we have new insertion of new parts. Insert 2 new parts immediately after part 4 as follows. Sports for schools and institutions of higher learning. Authorize sports activities for schools and institutions of higher learning. 1. The Council shall, with the approval of the Ministry and in consultation with the Ministry responsible for health, authorize the sports activities in which pupils and students in schools and institutions of higher learning may participate. 2. A school and an institution of higher learning shall offer at least 15 sports activities for the pupils or students, which shall be sports activities authorized by the Council under subsection 1. Participation in sports for pupils and students. A pupil and a student shall be entitled to participate in the sports activities offered by the school or institution of higher learning of the pupil or student as the case may be. National sports competitions. 1. The Ministry shall, in consultation with the Council, organize sports competitions for schools and institutions of higher learning for the sports discipline authorized by the Council under section 36. The schools and institutions of higher learning referred to in subsection 1 shall be categorized as A. Primary level schools, B. Secondary level schools, C. Tertiary institutions, and D. Universities. 3. The sports competitions for the primary level of education shall be for pupils of up to 14 years and up to 20 years for the post-primary level of education. 4. The sports competitions, including training for the competitions, shall be undertaken in accordance with the schedules issued by the Ministry, sports associations, and National Sports Committee. 1. For purposes of the national sports competitions referred to in section 38, each category of schools or institutions of higher learning referred to in this section shall have a sports association. 2. There shall be appointed each year a national sports committee to organize sports competitions for schools and institutions of higher learning for the specific year. 3. The national sports committee shall comprise 9 members who shall be appointed by the minister from amongst persons nominated by the respective sports associations. 4. For the purposes of subsection 3, each sports association shall nominate 20 members from whom the minister shall appoint members of the national organizing committee. Sports academies. Under sports academies, 1, there shall be in Uganda sports academies to provide specialized training in particular sports disciplines for athletes and sports persons who are minors. 2, the minister shall license the businesses that seek to operate as sports academies as may be prescribed by regulations made under this Act. 3, a sports academy to be registered under this Act shall, prior to registration, be approved for suitability for the sports discipline by the relevant sports federation. 4, the minister may, in consultation with the minister responsible for health, as may be necessary by regulation, prescribe A, the requirements for eligibility to operate as a sports academy, and B, for the condition to be fulfilled by a sports academy with respect to the academic schedule, the health care standards, and the nutrition requirements of the athletes. Justification: to promote sports in schools and institutions of higher learning. 2, to build capacity in sports through establishment of sports. Bullet 3, to identify young talent in school. Madam Chair.
Thank you. Amendment. Proposed amendment.
Madam Chair, there is a proposed amendment as far as sports academies are concerned, and it reads, there shall be in Uganda sports academies to provide specialized training in particular sports disciplines for athletes and sports persons, dropping the word minor because some of these academies go up to 23 years and minor is defined to be up to 18 years. And a person who seeks to operate a sports academy in respect to a sports discipline shall be licensed by the relevant national sports federation. A national sports federation shall transmit to council for registration the list of sports academies licensed under the subsection 2. A national sports federation shall, in licensing a sports academy, safeguard the welfare, rights, and the best interest of a child. And a person who is dissatisfied with the decision of the National Sports Federation under the section 2 above, under subsection 2, shall appeal to the council.
Eje.
Right, Honorable Chair, we agree with the issue that sports academies need to be licensed, but the question is by who? Government cannot give away, allow private citizens to license academies, because academies are taking in children, are taking in people. So we're proposing that a person who seeks to operate a sports academy in respect of a sports discipline shall be licensed by the council. The council, we can do it by regulations prescribed by the minister, which involve all the players to participate in that process, but government must know what that academy is doing, who is running it, who is there, what are they doing there. Because if tomorrow they come and tell us that there was an academy where 10 children died, we don't know about it. So government cannot relinquish that. So I was proposing that we amend 2 to read, a person who shall seek to operate a sports academy in respect of a sports discipline shall be licensed by council under regulations to be prescribed by the minister under this law.
Madam Chair, I would like to give the justification that within the international regulations, there is a protection which is given to the people who are developing these children in the academies, including benefiting from their transfers eventually when they become professionals after the age, even up to the age of 23 years. If they are not licensed by the federations, it means that whoever is participating in these sports academies will not benefit. And today's biggest business in player development is getting compensation in terms of the development of young players. We would believe that this would encourage the people who are investing in developing younger players to get a benefit. The way it is being worded, it leaves it open. The players can transfer the way they want to transfer, and there would be no benefit to the people who are investing in these younger players and creating these academies. For us, we think this would be detrimental to the development of these people, yet they should be protected and also help in the development. So we can harmonize a position. But what is important is that even what is taught in these academies, for example, is supposed to be a curriculum that is developed at the level of the federations. Because much as you are teaching, but what are you teaching? And who is the person teaching? Because right now as we speak, FIFA has come up with a curriculum for every country, not only Uganda. After doing research in every country, what do you need to do to a child who is 5 years? What do you need to do to a child as far as football is concerned? 10 years. So at the end of the day, when you say council will license, what are they licensing? And at the end of the day, what will they enforce? And how will they protect the people who are investing in this particular activity?
Why don't we say that council will recommend or will license with the recommendation from a federation? Let the federation recommend and council, because these are our children. The safety. Yes, so the federation recommends to council for licensing.
Thank you very much, Right Honourable Speaker, for your wise counsel.
I can see everybody sports promoters. Now let me first give
thank you, Madam Chair. Now, this thing for academies, if the government says that National Council needs to license them, that means to also take the clubs, the sports clubs, which is impossible. So I think the federations knows their regulations and how those academies are going on. Let me give you an example. We have academies, which we call academies.
What is your amendment?
In the federations should register, should license the academies. Then give that list to National Council of Sports.
Colleagues, not so long ago, we were here discussing, health centers. And we were saying, Parliament was saying that government must know the qualifications of the people who are dealing with these health centers and giving people massages because people are getting hurt. Now, if government doesn't know who is teaching your children how to swim in a swimming academy, if your child dies, who is responsible?
Honorable members, the licensing is only based on the approval of the federation. That is what is going to be done. The federation must approve the licensing. This is a new part.
Thank you so much, Right Honourable Speaker. Thank you so much, Right Honorable Speaker. Initially, when the AG submitted, I was on his side. I have children in those federations, rather in those academies. But when the member who sponsored private members bill made his submission, I moved to his side because we take our children to those academies for a purpose, to promote them, to promote the talent, to make them rise to those levels. But I also wonder when you say the council cannot recommend federations because council is a higher body and federations are being...
I'm not sure whether you say the council recommends.
It is initial, that's what you said. And
federations recommend these academies to the council.
Yes, and Right Honorable Speaker...
And why we are bringing in the council in this aspect is on the safety. That we as Ugandans, we are responsible for council. It's a government entity as opposed to a private federation.
Thank you, Right Honorable Speaker. Just to conclude my point, you initially advised that the minister is going to come out with an SI. In the SI, the minister would stipulate all what is required for these academies to be registered. And whoever is registering will have to comply with the instructions given the SI. I don't see a problem with the federation registering. So for me, I support the private member for the federation to register so that the talents of our children are promoted.
Yes. Madam Chair.
Thank you, Madam Chair. I actually agree with the recommendation that we should have the federations actually recommend. But I've got another issue on the earlier clause, which was about that every school should at least have 15 different sports activities. I'm actually concerned, those are quite a lot of numbers, 15 different sports activities. If we actually say if we name 15 different sports activities, some of our schools don't even have the space for that. I think the number is a bit big.
Madam Chair, when we talk about 15, let's understand our English, at least. But also this is a policy. It is actually erroneous for any school to operate without a sports facility. That school must be closed. Yes, so when you come out to say 15, at least we are dealing with at least. We are not saying that you can have all. Thank you.
Thank you, Madam Chair.
Honorable Ariko. Honorable members, what is the issue? What is the issue? Yes, let me hear from there, then I come back to you.
Right,
we are looking at licensing of the relevant nationals of the academies.
Right Honorable Chair, I thank you for the opportunity. I thank you because you have taken the House back to this particular element. When we define this facility as an academy, what is the understanding of an academy? An academy means that beyond the exercise of talent and expertise, there is the element of instruction. And instruction has to have guided curriculum. It therefore means that there must be somebody responsible for standards. And where are standards in education vested? That is the ministry. Therefore, there is no problem for the federations in processing, to process the documentation. However, the preserve of issuing of a license must be with a regulatory body that is directly attached to government, and that is National Council of Sports. I thank you, Madam Chair.
Honorable members, I wanted to inform my honorable colleague. Madam Chair, no, I'm not smuggling, I'm just informing him.
Can we hear from the private member first? And I want everybody with an academy to declare interest. Please declare your interest.
Madam Chair, if you look at the proposal by the committee, it is even talking about the ministry shall license the businesses. Now, these sports academies are not entirely set up for the businesses. There is also for the development. So when we are doing the modification, we need an approval from the federation.
Okay,
if we get approval,
make
then
for us the amendment.
Then we would have they would be in control of the regulations.
Make the amendment.
A person who seeks to operate a sports academy in respect to a sports discipline shall be licensed by the council on approval of the respective national sports federation.
Attorney General? On the approval of the federation.
No objection. Because what we are saying here is a shared responsibility.
I put a question that the new parts be inserted as proposed and amended by Honorable Magogo. Those in favor say and the contrary nay. The ayes have it.
Part 5.
We will correct the mistake. Part 5.
Madam Chair, substitution of Part 5. We have a new insertion, substitution of Part 5. Part 5 is substituted for the following.
Honorable Seungu, kindly listen.
Part 5 is substituted for the following, honorable members and Madam Chair. National Anti-Doping Organization. Establishment of National Anti-Doping Organization. There is established in accordance with the requirements of the World Anti-Doping Code, the National Anti-Doping Organization in Uganda. The National Anti-Doping Organization shall be a body corporate with perpetual succession and shall have an official seal. The National Anti-Doping Organization shall, in its own name, be capable of suing and being sued and may, for the discharge of its functions under this Act, A, acquire, hold, and dispose of movable and immovable property, and B, do all acts of things as a body corporate may lawfully do. Composition of National Anti-Doping Organization. 1. The National Anti-Doping Organization shall consist of the following members. A chairperson, and B, 4 other members with knowledge and experience in the field of anti-doping or sports. 2. The minister shall appoint members of the National Anti-Doping Organization on such terms and conditions as the minister may determine. 3. A member of the National Anti-Doping Organization shall hold office for a period of 3 years and is eligible for reappointment for 1 more term only. 4. A member of the National Anti-Doping Organization shall be paid such a remuneration as the minister may, in consultation with the ministers responsible for finance, determine. Functions of National Anti-Doping Organization. 1. The National Anti-Doping Organization shall promote anti-doping in sports in Uganda. A. And shall, for this purpose, 1. In collaboration with the ministry, develop a national strategy to address doping in sport. 2. Promote and implement the World Anti-Doping Code and associated international standards. 3. Periodically publish the international standards on anti-doping in the Gazette. 4. Provide athletes and athlete support personnel with the procedures for the collection and testing of samples of specimens as specified by the World Anti-Doping Code and international standards. 5. Select the sports persons to provide bodily samples for testing and collect the samples in accordance with the approved World Anti-Doping Code and international standards. And 6. Implement the Anti-Doping Administration and Management System Program. B. By testing and analyzing samples of specimens of sports persons using laboratories accredited by the World Anti-Doping Agency and securing the safe transmission of the samples to those laboratories. C. By undertaking or coordinating research or causing research to be undertaken in the field of performance, enhancing substances and methods and doping practices in sports. D. by carrying out investigations in matters of doping in sports, and may, for this purpose, summon any person and examine any document or evidence. E, by operationalizing the prohibited list of the World Anti-Doping Agency. F, by maintaining a whereabouts register and a registered testing pool. G, by conducting anti-doping education. And H, by carrying out any other function conferred under this Act and any other relevant treaty. 2, the National Anti-Doping Organization shall, in the performance of its functions, A, respect the rights of every person involved in anti-doping control process, including children and persons with disabilities. B, cooperate with the ministry and other ministries, departments and agencies of government and non-government organizations. And C, not require the consent or permission of any person or be under the direction of control of any person or authority. 3, the minister shall, by statutory instrument, make regulations to prescribe the management and effective functioning of the National Anti-Doping Organization. Justification: specifically create a National Anti-Doping Organization in Uganda as an independent body in compliance with the World Anti-Doping Code, which requires the World Anti-Doping Agency, an international agency created to promote and coordinate at the international level the fight against doping in sport in all its forms. The agency requires such bodies to be independent in order to ensure transparency and prevent its decisions being influenced. The proposal in the bill to have the National Anti-Doping Organization under the Council removes the required independence. Madam Chair.
AJ.
Right Honorable Chair, we have no objection to that inclusion.
Right Honorable Chair, I have no objection.
Private member.
No objection.
I put a question that Part 5 be amended as proposed. Those in favor say under control and A. The ayes have it.
Part 5 as amended.
I put a question that Part 5 as an amended stands part of the bill. Those in favor say under control and A. You will bring the omission in the next amendment.
Clause 32.
Clause 32.
There are no amendments. There are no amendments.
I put a question that clause 32 stands part of the bill. Those in favor say under control and A. The ayes have it.
Clause 33.
I put a question that clause 33 stands part of the bill. Those in favor say under control and A. The ayes have it.
Clause 34.
I put a question that clause 34 stands part of the bill. Those in favor say under control and A. The ayes have it.
Clause 35.
I put a question that clause 35 stands part of the bill. Those in favor say under control and A. The ayes have it.
Clause 36.
I put a question that clause 36 stands part of the bill. Those in favor say under control and A. The ayes have it.
Clause 37.
I put a question that clause 37 stands part of the bill. Those in favor say under control and A. The ayes have it.
Clause 38.
I put a question that clause 38 stands part of the bill. Those in favor say under control and A. The ayes have it.
Clause 40.
Clause 40.
Madam Chair and honorable members, clause 40, role of Uganda Olympic Committee. Substitute for clause 40 the following: continuation in existence of Uganda Olympics Committee. The Uganda Olympics Committee, in existence immediately before the commencement of this Act, is continued in existence subject to the provisions of this Act. For the Uganda Olympics Committee shall be a body corporate with perpetual succession and an official seal, and may, for the discharge of its functions under this Act, acquire, hold, and dispose of movable and immovable property. B, sue and be sued in its corporate name, and C, do all acts and things as a body corporate may lawfully do. 5, the membership of the Uganda Olympic Committee shall be in accordance with the provisions of the Olympic Charter. 6, the Uganda Olympic Committee shall, in collaboration with the Ministry and the Council, A, organize the participation of Uganda athletes in Olympic Games. B, promote the development of athletes and the training of coaches. and athletes participate in Olympic Games, and C, perform any other function prescribed under the Olympic Charter. 7. The Uganda Olympics Committee shall in the Olympic Committee shall in the performance of its functions under this Act and the Olympic Charter recognize a national sports federation that is registered by the Council. Justification: to provide for the continuation of the Uganda Olympics Committee, since it is already registered under the Companies Act and it is the National Olympic Committee recognized by the International Olympic Committee in accordance with the Olympic Charter. Bullet 2, to require the Uganda Olympics Committee to deal with only sports federations that are registered and recognized by the National Council of Sports to avoid confusion and ensure orderly participation of Uganda in the Olympic Games and other international games. Madam Chair.
AG.
We have no objection to that inclusion, Madam
Minister.
Chair.
I am at one with AG.
Member.
No objection.
I put a question
Madam
that clause
Madam
40
Chair,
be amended as
Madam Chair,
proposed. Those
before-
in favor say under control.
Madam Chair, before.
The ayes have it.
Clause 40 as
Madam Chair.
amended.
I put a question that clause 40 as amended stands part of the bill. Those in favor say aye to the control and nay. The ayes have it.
Clause 41.
I put a question that clause 41 stands part of the bill. Those in favor say under control and nay. I put a question that clause 41 stands part of the bill. Those in favor say under control nay. The ayes have it.
Clause
42. Chair 42.
Madam Chair, clause 42, prohibition of unlawful utilization of commercial rights. Clause 42 is amended by the numbering the current provisions as subclause 1, and thereafter inside a new subclause immediately after subclause 1 as follows. Court may, in addition to the penalty imposed under section 1, order the person convicted to pay to the National Sports Federation or athlete compensation equivalent to the value of the commercial right utilized. Justification: to provide for a civil remedy for the aggrieved party. Madam Chair.
AG.
No objection, Honorable Chair.
Member.
No objection.
Minister.
No objection.
On what?
Right Honorable, when the proposed amendment.
I put a question that clause 32 be amended as proposed. Those in favor say under control and nay. The ayes have it.
Clause 42 as amended.
I put a question that clause 42 as amended stands part of the bill. Those in favor say under control and nay. The ayes have it.
Clause 43.
I put a question that clause 43 stands part of the bill. Those in favor say under control and nay. The ayes have it.
Clause 44.
I put a question that clause 44 stands part of the bill. Those in favor say under control and nay. The ayes have it.
Clause 45.
45.
Madam Chair and honorable members, clause 45, prohibition of manipulation of sports results or sports competition. Clause 45 is amended in subclause 3 by deleting the words or intends to commit. Justification: to avoid ambiguity by clearly providing for the ingredients of the offense. Madam Chair.
Honorable private member, the amendment.
Madam Chair, clause 45 is amended in subclause 3 by deleting the word intends to commit. We agree with that, but would like part B by substituting the words council or a person authorized by the council with the words the respective national sports federation.
Attorney General.
No objection.
Honorable Minister.
Chair, you have to bear with me because of the issue of the Paralympic, and that's why you see.
Honorable Minister.
Honorable Mpima, I have no objection.
I put a question that clause 45 be.
I wanted to seek clarification on the 45(3) and 4. It appears that this clause is imposing. Madam Chair, it appears clause 45(3) and 4 is imposing criminal liability on a person who has not reported. If I get who has not reported.
AG.
We need that first to be very, very clear.
Yes, that's what it's doing.
Is that okay with you?
The member wanted to get clarification on the intention of the provision, and we told him yes, the provision is intended to penalize that person who knows of an offense and does not report it.
The problem with this is that somebody else has to know that the other person knew and never reported. And the chain will continue. Because how do you know that the other person knows and did not report? Exactly.
If I didn't know that you know, then you won't be arrested. But by the time I report that I know, I must have evidence of your knowledge. This is like aiding and abetting the commission of an offense.
Actually, when you look at Part D, it talks about the aiding and abetting. 45D. So, Jonathan, that's okay?
Chair, for me, the issue is 3. Because 45D...
No, you read draft the way you think it should
45D is already punishable under 4. So I wanted this 45(3) to be deleted. Because he's saying that a person who knows or has reason to believe that a person has committed and fails to report. It is very ambiguous, and when you are making a law, especially the one that sends somebody to prison, it must be very clear from the start. So if we are punishing aiding and abetting, then subsection 4 will take care of that clearly.
Subsection 4 talks about 5 years. Yes.
Madam Chair, the international practice about match fixing is about the 3 R's, and they are all punishable as if they are one and the same. One is you expected to resist. If you don't, you expected to report. If you don't, you expect to recognize. So you knowing and not reporting, you're actually part and parcel of it. That's the practice internationally where this has been legislated.
I put a question that clause 45 be amended as proposed by Honorable Magogo. Those in favor say to control a nay. The ayes have it.
Clause 45 as amended.
I put a question that clause 45 as amended stands part of the bill. Those in favor say the control a nay. The ayes have it.
Clause 46.
46.
Madam Chair, honorable members, clause 46, prohibition of acts of violence and hooliganism. Clause 46 is amended in subclause 1 by deleting the words organized by a national sports federation by substituting for clause 2 the following. For the purposes of subsection 1, a person shall be taken to have committed an act of violence or hooliganism at a sports event or sports competition where the act A leads to destruction or damage to property, B, physically injures a person, C, disturbs the peace and order at a sports competition or a sporting event, D, with the intent to disrupt a sports competition or a sporting event or to intimidate or annoy a match official, a referee, an umpire, a match educator, a coach, a trainer, an athlete, or any other participant in a sports discipline. Roman numeral 1 threatens, injures, assaults, shoots, or unlawfully restrains that person. 2, throws a projectile, a liquid, a substance upon or applies a fluid or substance to that person. 3. Incites a person to do an act of violence against that person, or 4. Abuses, uses absence of obscene language or gesture, or does any indecent act aimed at such a person. See, by inserting immediately after subclause 2 the following: a person who commits an act of violence or hooliganism at a sports event or sports competition organized by a national sports association or federation commits an offense and is on conviction liable to a fine not exceeding 480 currency points or to a term of imprisonment not exceeding 3 years or both. By substituting for subclause 3 the following: court may, in addition to penalty, impose this section: A. Order the person convicted to make good the loss and damage suffered by a person as a result of the unlawful action, and B. Make an order banning the person convicted from participating in or attending sports events and sports competitions for a period not exceeding 3 years. Justification: to avoid restricting the offense of violence and hooliganism to only sports event or sports competitions organized by the national sports federations. Bullet 2, to broaden the offense of violence and hooliganism to include use of obscene language, indecent acts, among others. Bullet 3, for clarity. Bullet 4, to provide for a reasonable penalty for the offense. The sentence of 10 years is too harsh given the nature of the offense. Madam Chair.
AG. There is an harmonized position from where they are saying they want to maintain 46 as it is.
Yes, we are proposing that we maintain 46 as it is. The same principles are being brought out here, but the drafting is extending it past the realms of possibilities. So we're proposing that we leave 46, clause 46 as it is in the bill.
Honorable Minister.
Honorable Chair, I agree with the Attorney General.
Member.
No objection.
Chair. Concede.
Madam Chair, I concede.
I put a question that clause 46 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 47.
47.
Madam Chair and honorable members, clause 47, prohibition of exploitation of participants in sports activities. Clause 47 is amended in subclause 1 by deleting the words organized by a national sports federation. Justification: to allow the offense of exploitation of participants in sports activities to apply to all sports events or sports competitions. Madam Chair.
AG.
No objection.
Minister.
No objection.
Member.
No objection.
I put a question that
Chair, I want to propose a new subclause that in addition to the punishment provided, court may award compensation or damages to the victim, because we are talking about sexual exploitation, financial exploitation, and emotional. I'm saying I want to propose a new clause 3 under 47, because it's talking about sexual exploitation and financial exploitation. So that 3 reads that in addition, court may award appropriate damages or compensation to the victim of the sexual exploitation or financial exploitation.
Yeah, if on top of criminal liability the court is to grant such penalty, then we can legislate on it. I have no objection to that myself.
So what's the amendment?
The amendment is adding clause 3 to section 47 to read that the court may, on top of the penalty granted in 2 above, grant a compensatory penalty, a compensatory award to the victim.
I put a question that clause 47 be amended as proposed by Honorable Drew and Attorney General. Those in favor say on the contrary, nay. The ayes have it.
Clause 47 as
I
amended.
put a question that clause 47 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
New clause.
New clause, Chair.
Madam Chair and honorable members, we have new clauses. Insert new clauses immediately after clause 47 to read as follows. Offense of illegal participation in sports competitions for schools and institutions of higher learning. A person shall not falsify the information of the identity, age, or level of education of a pupil or student who participates in a sports competition, or B, offer a parent or guardian of a pupil or student, a coach, a teacher, money, or any other form of payment or settlement in exchange for the enrollment of registration or the transfer of the pupil or student in a specific school or institution of higher learning in order for the pupil or student to participate in a sports competition for that school or institution of higher learning. 2, a person, A, who is not a pupil or a student of a school or institution of higher learning shall not participate in a sports competition as a pupil or student of the school or institution of higher learning, or B, whose age is above the age specified under the law, shall participate in a sports competition, or shall not present for participation in a sports competition a person who is above the age as specified in this act. 3, a person who contravenes this section commits an offense and on conviction liable to a fine not exceeding 2,000 currency points or to imprisonment for a period not exceeding 10 years or both fine and imprisonment. Prohibition to act as an agent, promoter, or manager of athlete without registration by a national sports federation. A person who is not registered by a national sports federation as required under section as required under this act shall not act as an agent, promoter, or manager of an athlete. A person who acts as an agent, promoter, or manager of an athlete contrary to this act commits an offense and is liable on conviction to a fine not exceeding 500 currency points or imprisonment for a period not exceeding 3 years or to both fine and imprisonment. Madam Chair.
Thank you, Chair. Is in the 10 years too harsh? AJ?
This particular space where we have provided for 10 years, where the committee is proposing 10 years is not too much, because this area is where we may look at things like human trafficking. An agent takes children, starts saying I'm an agent, so you don't know them. So you do not want to reduce this. I have no objection. It's a committee's proposal, but I'm happy with such a deterrent penalty. So I have no objection to the amendment.
Love?
Thank you, Chair. The Land Attorney General needs to help this House in making this, because we are not necessarily enacting a penal law. And when you look at the offense that this law is, this provision is creating, it's not creating a capital offense for 10 years, because we distinguish that from other offenses that are of a capital nature. This for me should simply be a misdemeanor, not necessarily a capital offense to attract that
Is
kind
human trafficking a capital
No, we are not dealing
offense?
with capital with human trafficking directly. It's just importing, you know, and when you are importing just the meaning, or to even mean that to justify the penalty, I want to invite the Land Attorney General to look at it further.
Madam Chairperson, the power to determine the penalty lies with this House. The committee has proposed 10 years. The Landed Attorney General does not have an objection to it, but the House can guide.
Well, Leader of Opposition, can you guide what you think is sufficient? That is deterrent.
First of all, Right Honorable Speaker and Chair, we need to agree that the provision is not intended on creating an offense capital in nature, but one that would deter participants in the sporting event not to falsify particular obligations. And if it's a misdemeanor, I will go for 6 months.
Yes, can I hear from the chair?
Madam Chair, the committee took a long time to deliberate on this. And here we are not saying that the person must be in prison for 10 years. It is not exceeding 10 years. It can be 3 months, it can be 6 months. So
are you taking it?
Information.
Yeah, Madam Chair, I want to thank my chair. Madam Chair, when you talk about 10 years as stated in the law, the judge has discretionary powers for the period. Secondly, 10 years is not for capital offense. It cannot. It is not capital offense because that is life imprisonment or death.
He has said not exceeding 10 years.
That means
it can even be 1 day.
1 year. So
not 1 year, 1 day. It is at a discretion of the
discretion.
judge.
That's what I'm saying, Madam Chair.
Let's be clear. Of course, this is the new clause that is being introduced, and we are talking about offences of illegal participation in sports act competitions for schools and institutions of higher learning. So we are talking about children, and teachers to this matter. So to imagine that somebody either erroneously or by misrepresentation makes a mistake and you import a penalty of 10 years, for me is really so strenuous. Yeah.
Honorable Law?
I would go for still remain for 6 months.
Honorable Law. Honorable Law. What is the difference between 6 months and not exceeding 10 years?
You know, when you say not exceeding 10 years, you've left latitude for the discretion of court to determine the sentence. But you see, why we distinguish between offenses is to guide the court within limits within which they cannot exceed particular, offenses. So I don't think we should leave it for court and, out of, for example, if the school from which the Land Attorney General started from loses a match and is at the bench and wants to determine an offense out of angle of losing, I'm not saying he will do that.
Actually, Lob,
we're trying to be as considerate as possible.
Lob, I know where your concern is coming from, being one of the owners of schools. And now we are dealing with the children. When our children are sodomized, when our children are trafficked, it's a very serious thing. We need to have a stringent measure in this issue. We are all owners of schools,
Madam Chair,
but we must be very...
Let the chairperson introducing a new provision read it again and the intentions, because for every provision there is an objective, then we can understand this better. What you're saying, Honorable Chair, is not the intention of this new provision. It's different. It's different.
Chair?
The objective is different.
Chair, I wanted the move of the private bill to help us in this situation. Even on the scale of weighing the offense, under 41 which is about doping. Under 41 we have passed. You refer somebody who has abused substance to be subjected to the World Anti-Doping Agency sanctions. What are those sanctions, if you could benefit from those? Because if somebody who has been caught in substance abuse, that for me appears to be even a very serious offense than the one who has just falsified the age, and you are referring them to the World Anti-Doping Agency sanction, then how do you come to this other offense and create it to even be more serious than the one? So if you could benefit, how is FIFA handling that so that we bring that standard into this law?
Madam Chair, for information, some of the substances that are banned on this list are actually drugs for other diseases. So don't look at it when they say banned substance to mean the hardcore end of drugs. Some of you are actually taking some of these drugs for different ailments.
Honorable members,
Madam Chair, in order to
can we work on the issue of the period?
In order to move this along, the committee, and that's, I'm thinking the committee in the second offense did propose a period not exceeding 3 years, or both. Maybe we can put not exceeding 3 years, or both.
Yes, then you harmonize the current points.
Yes.
Love? Love?
Yeah, I would like again to make a final invitation from the chairperson and Land Attorney General to imagine, you know, sports indiscipline does not necessarily run on imprisonment. I would rather go for bans and financial, you know, penalties. And I would like to move away from imprisonment to bans of particular periods and financial penalties than imprisonment. That's what I want him to invite. And I would go for...
Honorable Lope, I beg you, I request that we go for 3 years. Where we see that is too harsh, we'll come back and amend it in this house. Kindly.
No, let's do both. Let's create the option of a ban for a particular period, imprisonment, and then financial penalties. 3 options.
Madam Chair, the challenge with the ban is that some of the perpetrators of these actions are not part of the sports community. So what do you ban them from? You cannot ban somebody who is not part of the association.
When your boss has spoken, keep quiet. Let me first allow Honorable Ariko, because he was one of the people who suffered out of being stoned.
I thank you, Right Honorable Chair. The Chair is speaking about the scar that I have on the face, courtesy of the comrades of the Land Attorney General of Express FC. Express FC people. Honorable Chair, besides what the Honorable Moses Magogo has mentioned regarding the people who may not necessarily be part of the sport, on the aspect proposed by the Honorable Leader of Opposition of a fine, we must also look at what is the industry we are dealing with. In some of them, the amounts of money involved are very colossal. So much so that the moment we put in the legislation a fine, the persons will simply go to court with a view that whatever the penalty that I'm given, I'll simply pay and go back to the same thing without a deterrent. The law must provide for penalty that is deterrent. I thank you, Honorable Chair. Yeah.
I seek your indulgence. And the confusion began from the learned Attorney General. Look at the head note of this provision. It is talking about offense of illegal participation in sports competitions for schools and institutions of higher learning. That is the head note. And then you are talking about falsifying information of the identity, age, level of education of a pupil or student who participates in a sports competition at that level. Now, the discussion here is assuming that this goes to the general sports we are talking about. Let us focus on the head note. Because even that's why you are even landing into problem of creating penal provisions of 3 years. You are forgetting you are dealing with the children.
Honorable Gemma, we are talking about schools and institutions of higher learning. Exactly. That's what we are talking about. And that's why we are saying we now harmonize the 3 years plus the currency points vis-a-vis what leader of opposition was proposing. So the amendment, can you move the amendment?
And maybe Chair,
I move.
As it comes.
We have a very important report that is coming on this floor.
But Chair, maybe as it comes, Chair, the learned Attorney General, consider the fact that these are pupils and students, and two, consider that these are institutions of higher learning that actually aid and abet. Capture that.
Yes.
Thank you very much, Right Honorable Chair. Our clubs, our football clubs in the Premier League are supplied by schools and institutions of higher learning. All our players are from this place. So what we are telling you is that when these people do this, they kill the sport that we are going with. So I'm proposing, Madam Chair, that having taken into consideration that we are dealing with students and people who are pupils, I'm proposing that a person who contravenes, proposing that it reads as follows: a person who contravenes this section commits an offense and on conviction is liable to a fine not exceeding 2,000 currency points.
No, 500. We agreed
500 currency points, sorry, or to imprisonment not exceeding 3 years, or to both fine and imprisonment. I beg to submit.
Chair, I and the Attorney General are officers of court, and we have a duty to this House. The proposals you have also have implications on criminal liability. Because we're talking about children. I want in your proposals to put that into consideration. Because you see, if you don't do that, we are making a disservice to this Parliament and the country.
Honorable Basalirwa, I have put it into consideration. This offense here is telling you, Honorable Basalirwa, at the young age of 25, going and holding out in a school that you're 17 and you participate in those that's the kind of offense you'll commit here. And right honorable Speaker, the issue of penalties is an option, a discretion that is going to be exercised. It starts with fine, imprisonment, or both, depending on the gravity of the offense you have committed or the circumstances surrounding that offense.
Honorable Attorney General. Attorney General, I want us to read from 2. I want us to read from 2. A person who is not a pupil or a student of a school or institution of higher learning shall not participate in a sport competition as a pupil or a student of the school or institution of higher learning, or whose age is above the age of a specified section, shall not participate in a sports competition, or shall not present for participation in a sports competition. A person who is above the age specified under that section, that person contravenes the section that a person who contravenes this section commits an offense. Now, we are not talking about the children.
Yes, we are talking about Honorable Basari who are going to the university and holding out to be a student.
Becoming a muchuba.
Yes, becoming a muchuba.
No, I am reading from the amendment.
Madam Chair, Madam Chair,
Speaker.
we need to be practicable.
But Honorable,
Just a moment. Madam Chair. Chair, I just want
Honorable members,
Chair.
I am reading this from
Yes.
the amendment.
Yes.
It is not anything that is brought from nowhere. We are trying to destroy this Vachuba. You are the same people who went to Sudan and you are complaining how Sudan brought people who were Santa. Let Santa contribute. Honorable Santa.
Yeah, thank you. Thank you so much, Madam Chair. Madam Chair, I stand to give the experience that we always have in the sports competitions, where we have the bachubas, people who, for us in our games as parliamentary sports, we are supposed to deal with members of parliament and the staff of parliament. But here we are faced with a very difficult competition arising from other participants, bringing even professionals. So, Madam Chair, I would like to urge my brothers, the chairperson of the sports, having experienced this in our own competition, to really support this proposal from the committee. Because, Madam Chair, we are not here to promote immorality as far as sports is concerned. So I encourage and advise my chairperson of the parliamentary sports to really support this, so that we iron out this from the national perspective and even go down to our own sports. If we begin supporting this, and the penalty to me, Right Honorable Chair, is talking of not exceeding 3 years, which I think is not too much, Madam Chair.
Thank you. That's the Vice Chair. Let me hear from the former, that's the manager of sports. Let me hear from the former Minister of Sports. And he's the one who boxed the Bachuba.
Right Honorable Chair, that one is not true.
No, that was a light moment.
Right Honorable Chair, I want to speak with evidence. And I want to speak in support of the committee's proposal. When I was Minister of State for Sports, we were faced with all these challenges, where first of all a school gets a non-student of the school. After getting the non-student, they move ahead to even procure the process of getting our passport. But when the age is reduced, I have here, Right Honorable Chair, I can print and lay on table. I may not go into the details of the name. Now, this particular student, in his first passport, he was born on 9th of October 1996. And the passport is A002-36115. That is the passport number. The second passport that was procured by the school that wanted to use him as their athlete, but in the league of those who are younger, his date of birth is 9th of October 2004. He has reduced his age by 8 years, and the passport number is A00-444-668. I may not mention the name, but if you want me to print, I can print and lay on table. Now, the first passport of 1996, where does he come from? His place of birth is Bukwo. In the second passport, his place of birth, this is a runner, for clarity. His place of birth is called Chelelele Bay. But this is the same person, the same picture. Now, if this is not criminal, if we cannot criminalize such an somebody has reduced his age by 8 years. Now, for me, at 40 plus, I want to run with those who are 30. Isn't that criminal?
Honorable Leader of Opposition, that can even injure our children. Yes, Leader of Opposition.
Thank you, Chair. I hear my friend and comrade, the Honorable Hampson. But you see, let's get to understand what actually the chairperson and the Land Attorney General did not cure, which really for me is sticky, is schools, sports competitions. Schools should be handled differently. And you see, the offense of falsifying a passport is another offense. It has nothing to do with sports. It should be handled as such. Because if you want to really handle that person, there are other laws of the land that can deal with that. We are dealing with sports. If we want to leave this the way it is being proposed, then we should remove schools, competition, and call it offenses of illegally participating in a sporting activity, and remove schools. In which case the entire text will change.
We can remove that. That's okay. We can have that amendment and take it back to 10 years. Let's have the amendment and take it back to 10 years.
I propose, Right Honorable Chair, that we can amend it that way, because even schools competitions will be covered in this. The only problem is maybe the penalty is a little smaller, because the person who changes from 8 years is normally like...
No, let's now look at it in terms of, we remove the institutions, the schools institutions, and take it back to 10 years.
Yes, thank you.
You know, why I was insistent, Chair, is because in that text, the way it is, the title, would the penalty proposed does not distinguish juvenile offenders, and is going to cause a problem in when you are raising the sentence, because it does not offer the distinction. It just embraces everyone. Yet under it you have juveniles. So we remove schools, then leave it general, then the courts will have jurisdiction to apply other attendant legislation to handle the offenses that they arise.
So you redraft?
I need a minute to rethink through, or probably the Land Attorney General having picked it.
I thought you only redrafting now
once the principle is agreeable, redrafting can be done. I don't think that's a problem. And we'll listen in.
Redraft on the head note
is the offense of illegal participation in sports competitions. And it reads that a person shall not, it's a long one, shall not, but I'm going to get to 3.
Wanted you to redraft.
A person who contravenes this section commits an offense, and on conviction is liable to a fine not exceeding 500 currency points, or to imprisonment for a period now not exceeding 10 years, or to both fine and imprisonment.
But then you need to in drafting, you need to falsifying information of identity of age, level of education of a pupil. You remove that of a pupil or a student.
I think the biggest offense.
It should be of a person.
We will redraft, and where we have pupil, put person, so that it is consistent. Actually, the LOP's proposal is more inclusive. It is a better proposal. Thank you.
I put a question that a new clause be inserted as proposed by Leader of Opposition and amended by Attorney General. Those in favor say on the contrary, nay. The ayes have it.
Clause 48.
Madam Chair, honorable members, clause 48, general penalty. Clause 48 is amended by substituting for the word 3 the word 1. Justification to provide for a reasonable penalty. Madam Chair.
AG?
No objection.
Minister?
No objection.
Member?
No objection.
I put a question that clause 48 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 48 as
I
amended.
put a question that clause 48 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
New clauses.
New clause. New clauses.
Madam Chair, honorable members, under new clauses, insert 3 new clauses immediately after clause 50 to read as follows. Prohibition of dealing with counterfeit sport materials. A person who imports, manufactures, distributes, produces, sells, offers for sale, or trades or displays for sale any counterfeited Ugandan sports branded material, attire, apparel, or any other item without the authorization of National Sports Federation commits an offense. A person who contravenes subsection 1A is liable on conviction to imprisonment for a period not exceeding 5 years or to a fine not exceeding 120 currency points, or both. And B, shall, in addition to the fine or penalty imposed under subsection 2A, pay the National Sports Federation damages and compensation for the loss suffered by the National Sports Federation. Prohibition of unlawful access to sports events and competitions. 1. A person who, without authorization, enters, stays, remains, or allows a person to enter, stay, remain, or access a sports event or competition organized by a National Sports Federation commits an offense and is liable on conviction to a fine not exceeding 120 currency points or imprisonment for a period not exceeding 1 year or both. 2. A person who contravenes subsection 1 may, in addition to the fine or penalty imposed under subsection 1, pay the National Sports Federation damages and compensation for the loss suffered by the National Sports Federation as may be determined by court. Prohibition of electronic media production of sporting events and competitions. 1. A person who, without authorization of a National Sports Federation, captures by camera the still or moving pictures or records by an audio recorder activities at an event or competition organized by a National Sports Federation commits an offense and is liable on conviction to a fine not exceeding 120 currency points or a term of imprisonment not exceeding 5 years or both. 2. A person who contravenes subsection 1 shall, in addition to the fine or penalty imposed under subsection 1, pay a National Sports Federation damages and compensation for the loss suffered by the National Sports Federation. Imposition of administrative penalties. 1. The Council may, in addition to or as an alternative to the prescribed penalty, impose administrative penalties on a person, body, or entity that infringes the provision of this Act. 2. The administrative penalties imposed by the Council shall not exceed the fine imposed for breach of the relevant provision of this Act, and where no fine is imposed, the administrative penalty shall not exceed 500 currency points. Justification. The new inserted clauses have been carried from the National Sports Bill 2021, take care of additional offenses prevalent today in sports administration, and to provide for administrative mechanisms of handling breaches. Madam Chair.
AJ.
Thank you, Right Honorable Chair. I have no objection to the inclusion of these new offenses and the penalties. However, I have an objection to this imposition of administrative penalties by the National Council of Sports. It breaches fundamental rules of a fair hearing, 1, but number 2, it is
unconstitutional.
Yeah, so I'll propose that that be dropped, and we have no objection to the rest of the proposal by the committee.
Right Honourable Chair, I agree with the proposal of the Attorney General.
Member?
I agree with the proposal as amended by the Attorney General.
Law.
Thank you, Madam Chair. The sport is supposed to be fun and enjoyed. The introduction of the second sub-clause 2 relating to media taking of pictures. You see, as long as you have allowed in people in a facility who have paid their money and with their phones, administratively, what are you trying to tell them? And you see, we should really abhor international practice. People enter stadia with their phones, take pictures, wait for selfies of their, you know. You're denying people light moments. I think this is not necessary for sports. We're not enacting a penal law. We're enacting a facilitative legislation to sports. I would like to invite the chairperson and the movers of the bill to drop this provision because it infringes on the right to enjoy sports. It's like we are inviting people to a sport and then cage them. I really have not found reason to justify that because, first of all, you will allow in licensed journalists. But in the new world order, everyone with a camera you have allowed in is a journalist in their own right. And there are laws that govern infringement of privacy within the stadium. And the two are different. So where would be the infringement if somebody took a picture of a sport for which they have paid to be a part of? I would like to invite the movers and the chair to drop this provision.
Assuming you put it in a way that is prohibition of unlawful electronic media production.
Justification. If you read what has been provided, remember in the beginning we talked about national associations and federations, and we are talking about federations here where we are talking about amateur and professional sport. And we have defined the professional sport to mean sporting activities for financial or economic benefit as a business. As you are all aware, the sporting industry, we keep talking about it, is a $600 billion business worldwide, and Uganda, we are not partaking simply because people undertake activities, as we are saying. What we are providing, so we are saying without authorization. Now, when you do authorization, it means you accredit people, it means somebody buys the ticket, and in the terms of reference, may as well undertake what LOP is talking about. But if you don't control that, what happens is that anybody is free, will record whatever they record, will make a financial benefit, and the actual artist who is supposed to be benefiting from this, you'll just go and play, and at the end of the day, somebody broadcasts that, and there's nothing you benefit out of it. Elsewhere, this has been regulated.
We are talking about authorization and the TV rights. Basalirwa, Seconda.
Thank you very much, Chairperson. Chairperson, I think the focus here seems to lie more in broadcasting rights and licenses. That's what I want to imagine. And the provision should be structured in such a manner that the issue of broadcasting by any means without authorization should be penalized. Then we try to address what the broadcasting is, because the way it is structured, yeah, okay, you explain authorization by buying a ticket. But in express terms, that may not amount to authorization. And I think this is where the problem is. You want to preserve the right of the federation to derive benefits from an event. That's perfectly okay. You don't structure it in this manner, with due respect. So I would rather, learned Attorney General, that we focus on protecting broadcasting rights. And anybody who does broadcast in whatever form without authorization should be penalized. And then the thing changes.
Proposed draft.
Proposed redraft. A person who, without authorization of a national sports federation, captures by camera the still or moving pictures or records by an audio recorder activities of an event or competition organized by a national sports federation for commercial purposes commits an offense and is liable on conviction to a fine not exceeding 120 currency points or a term of imprisonment. I beg to submit.
I put a question that a new clause as amended by Attorney General be inserted. Those in favor say aye, and to the contrary nay. The ayes have it.
Clause 49.
Clause 49, I put a question that clause 49 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 50.
I put a question that clause 50 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 51.
I put a question that Chair.
Madam Chair and honorable members, clause 51, vesting of sports infrastructure in council. We propose delete clause 51, justification to avoid contradiction with clause 21. Madam Chair.
Yes, AG.
That's correct. I have no objection.
Minister.
No objection.
Member.
No objection.
I put a question that clause 51 be deleted as proposed. Those in favor say and the contrary nay. The ayes have it.
New clause.
Go ahead with your notice. I thought you had given a notice. You are given us a notice, you're bringing an amendment, a repeal.
Yes.
Yes.
At this point.
At this point, yes. No, you're going to bring a formal motion. We are going to reach 54 on repeal. Yes. Fifth, new clause.
Madam Chair, honorable members, new clause. Insert a new clause immediately after clause 51 to read as follows. Settlement of sports disputes. A sports dispute shall be determined through arbitration in accordance with the Arbitration and Conciliation Act Cap 4. The Council shall provide a list of arbitrators from whom parties to a sports dispute may choose an arbitrator. 3. The Council shall update the list of arbitrators annually. 4. A person shall not be qualified to be included on the list of arbitrators referred to in subsection 2 unless the person has A. Technical knowledge in sport, B. Experience in sports administration and management, or C. Participated in a sports discipline. 5. The Council shall publish the list of arbitrators under subsection 2 in the Gazette and a newspaper of national circulation. 6.
Of wide circulation.
Of wide circulation. Thank you, Madam Chair. 6. Each party to a sports dispute shall bear the costs it incurs during arbitration. 7. A national sports federation shall provide in its constitution the following. A. The determination of sports disputes between the National Sports Federation and its members through arbitration. And B. An obligation on a National Sports Federation and its members to comply with a decision arising from arbitration. 8. The Council shall not register a National Sports Federation that does not comply with subsection 6. 9. In this section, sports dispute means a dispute between a National Sports Federation and its members or any other person relating to A. The interpretation of the Constitution of a National Sports Federation, B. The interpretation of statutes and rules governing a sports discipline, or a decision taken by a National Sports Federation in exercise of its functions under this Act, Constitution or statutes and rules governing the sports discipline. Justification. Provisions on settlement of sports disputes are to introduce practices that allow settlement of sports disputes by persons with knowledge and experience in sports matters in order to ensure timely and efficient determination of sports disputes. Madam Chair.
AG.
Right, Honorable Chair, we have a proposed amendment. We are keeping the principle. I think let the private member move this.
Madam Chair and colleagues, once again this was provided to the committee, so I would like to propose to make some amendments as follows. That in addition, we continue to say the minister, instead of the council, shall appoint from nominees made by council and each national sports federation. The justification being that council may also be subject to the same list of arbiters. The parties to a sports dispute may choose at least 3 arbiters from a list of arbitrators appointed under subsection 1, and for avoidance of doubt, the number of arbitrators chosen by the parties shall be an odd number. The minister shall update the list of arbitrators once in 2 years. 5, a person shall not be qualified to be appointed an arbitrator under subsection 1 unless he is an advocate of the High Court, has worked with the National Sports Federation for at least 3 years, has not been convicted of an offense under this act, has not been declared bankrupt by a competent court, has not been banned by National Sports Federation for an offense for a period more than 3 years from the date of appointment. The minister may remove an arbitrator for inability to perform his or her functions arising from from mental incapacity, abuse of office, misbehavior, misconduct, incompetence, or failure to handle at least 3 sports dispute resolutions once appointed by a party to the dispute. For purposes of arbitration in respect of a matter which this act has not expressly made provision, the Arbitration and Reconciliation Act shall apply with the necessary modifications. Costs of arbitration: each party to a sports dispute shall bear its costs it incurs during arbitration. Notwithstanding subsection 1, every national federation shall pay an annual arbitration fee to the council, and the minister, by statutory instrument, shall prescribe the amount of the annual arbitration fee referred to in section 2. The council shall apply the arbitration fees referred in subsection 2 to offset the costs incurred during arbitration. Arbitration to be provided in the constitutions. There shall be a provision in the constitution of every national sports organization. 1, recognizing the jurisdiction of the arbitrators appointed under this act and obligating the settlement of sports disputes between the national sports organization, its members, and the council. 2, recognizing the decision of the arbitrators as final. 3, obligating a national sports organization and its members to respect and comply with the decisions of the arbitrators. Also in the Constitution, there should be a provision of prohibiting the settlement of sports disputes between the national sports organization and its members by courts of judicature, including interpretation and application of the Constitution and regulations of the national sports organization. 2, a constitution of a national sports organization that deviates or does not make a provision for matters referred to in subsection 1 shall be null and void. And 3, the council shall not register a national sports organization that does not include provisions prescribed in subsection 1 in its respective constitutions. I beg to move.
Thank you. AG.
I have no objection.
Minister.
I have no objection.
Chair.
No objection, Madam
I put
Chair.
a question that a new clause be inserted as proposed as a proposed amendment by Honorable Magogo. Those in favor say on the contrary nay. The ayes have it.
New clause.
New clause.
Madam Chair and honorable members, new clause. Insert a new clause immediately after clause 51 to read as follows. Participation of minors in sports activities. A minor of 16 years of age or more may participate in sports activity with adult participants. 2, for the purposes of subsection 1, the sports activity shall be shall be authorized by the council in accordance with this act. The minor and the parent or guardian of the minor shall receive a legal advice on the matter from the organizers of the sports activity, and the parent or guardian of the minor shall give consent in writing to the participation of the minor, and C, where payment is to be made for the participation of the minor, the parent or guardian of the minor shall enter into a contract for the minor with the organizers of the sports activity. Justification: to regulate the participation of minors in sports activities. Madam Chair.
AG.
I have no objection.
Minister.
I have no objection.
I put a question that a new clause be inserted as proposed by the committee. Those in favor sign the contrary nay. The ayes have it.
Clause 52.
Regulations.
Madam Chair and members, Clause 52, regulations. Clause 52 is amended in subclause 2 by substituting for paragraph A the following: for the management and maintenance of public sports facilities managed by the council. Justification: to ensure clarity. Chair.
AJ.
Madam Chair, I'm proposing that it's a consequential amendment to what we have already done for management and maintenance of public sports facilities vested in the council.
Yeah.
I beg to move.
Yes, Minister.
Madam Chair, I support the proposal which AG has brought forward.
I put a question that clause 52 be amended with the proposal, with amendment of the proposal by the AG. That in favor say to the contrary nay. Let's have it.
Clause 52 as amended.
I put a question that clause 52 as amended stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 53.
I put a question that clause 53 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 54.
Madam Chair and honorable members, clause 54, repeal and savings. Clause 54 is amended by substituting for subclause 5 the following: a national sports federation existing immediately before the commencement of this act shall, within 12 months from the commencement of this act, comply with the provisions of this act. Justification: to require the existing national sports federations to comply with the provisions of the proposed law within 12 months of its commencement. Madam Chair.
AG.
Madam Chair, I'm proposing a redraft. One, I'm proposing to keep clause 5 as it, 54.5 as it is, and add to read as follows: to add another part to deal with bring it. A national sports federation which was duly registered by the council before the commencement of this act, and which is in existence before the commencement, shall have the effect as if it was registered under this act, provided it shall, within 12 months from the commencement of this act, comply with the provisions of this act. The provision as had been proposed by council did not tell me what happens between the date we gazette and the date they comply. So I wanted to make sure that the sports federation remains alive for that period, and after 12 months, that's when it can be considered to have failed.
Okay.
I beg to submit.
Minister.
Madam Chair, I support the amendment proposed by Attorney General.
No objection.
Oduru. Asumani.
Thank you very much, Honorable Speaker. Chair, I want to propose an amendment to section, to clause 54 by including the following provision: 54A. Yes, the new clause before one. Yes, new clause before one. to read as follows, right, Honorable Chairperson, that the Nakivubo
Honorable Basalirwa, didn't we grant you leave on Nakivubo? Under miscellaneous.
Chair, you did. And when we were...
you're somersaulting.
No, not somersaulting. Chair, you recall.
So what happens to what we granted you leave for?
Okay. You remember the leave you granted me had about 7 pieces of legislation that I was addressing. When the bill went before legal and parliamentary, the Attorney General rarely and graciously conceded to including my views in the government bill. Because you recall, there was a government bill and my bill. So he graciously conceded to remove Section 8 of the Public Order Management Act, Section 50 of the Penal Code Act, and the others. And in Nakivubo, his advice and guidance was that it could not be handled under law revision miscellaneous amendment. And we were in Entebbe, members of the legal and parliamentary are here, including the Vice Chairperson Mutembuli. When we were in Entebbe, the Attorney General advised that Nakivubo could not be handled under law revision miscellaneous. And he said, either you bring a bill to repeal it or have it discussed under the parent law, which is this one. So it is in that spirit, Chair.
Is this the parent law?
Not a parent law, but a sectoral law. It is a sectoral law. It is a sectoral law. And I want to propose, Chair, because this is a matter which was discussed even in the committee. It's not something it is a sectoral law. So I want to use this opportunity, and I actually did inform the Committee on Legal that once the views are captured, then I will come here and have my private members' bill withdrawn. Because then everything will have been captured. In the premises, Chair.
May I information? First of all, Mr. Honorable Basairwa reports candidly of our conversation in the committee. He is right, he raised the issue, and I did advise him that he brought it under the wrong law. That is correct. I also did advise him that maybe he could consider another law where he could consider it. However,
correct the record. You did not advise that I brought it under the wrong law. My conviction is that it is the right law. But
Okay.
You said it would be better covered here. Because you are assuming I don't know the law, which is not correct. You also know that I know the law.
well, Mr. Basairwa knows the law, and I think he knows that if he brings a motion here to amend the Nachivubo War Memorial Stadium Act, which is seated with properties belonging to government, will have a financial implication on the government because those properties belong to government, and that would be contrary to Article 93. But he knows the law. I beg to submit.
Chair, I beg that you allow me move the amendment, and I'll make a justification. Chair, I beg to move that we add immediately after clause 54, repeal and savings, 1, that the Nakivubo War Memorial Stadium Act Trust Act be repealed. Cap 47 be repealed. Justification 1, to create a single uniform law governing management and administration of sports and sports facilities. Chair, we are making a law on sports and sports facilities. And now we are being selective. We are leaving some facilities outside a law which is supposed to govern sports and sports facilities. We now have an opportunity to have a uniform single law that encompasses all sports facilities in the country, not leaving some outside unjustifiably and then putting others here. This is the time and opportunity to have a single uniform law that encompasses all sports facilities and sports management and administration in the country. I beg to move.
Yes, sir. One, we oppose that for 4 reasons. One, the Nachivubo War Memorial Stadium Act provides for vesting of properties of government in that law. And if you repeal it, the properties are left hanging. The proposal he made was to repeal the law. So if he repeals the law, he has not provided for a replacement.
Now let him finish his submission.
Order. It's under the rules order.
Yes.
The Attorney General moved an amendment here, vesting all public sports facilities. He's the one who moved it under National Council for Sport, which is government. How come then that he comes here and changes his position, and yet in an earlier clause we had already, on his move, vested all public sports facilities, including Nakivubo, in National Council of Sports?
No, there was no an inclusion of Nachivubo because Nachivubo has its own act.
Under that act, I moved an
UBC, inspiring Uganda. Up next on